You may proceed.
Thank you, Your Honor. Dr. Katz, are you suggesting to the jury that you don't often see false claims of sexual abuse by teenagers?
Yes.
Have you published any articles on that subject?
I have not.
What research have you done on that subject?
I have read probably all the current research on jeopardy in the courtroom, which cites all the research regarding children in the courtroom regarding molestation.
Now, tell me what research you've done into how many civil cases have been filed by plaintiffs who are teenagers in the area of sexual abuse and how many have been won or lost.
I have no research about that.
No further questions.
Doctor, do you have personal experiences involving your own caseload over the past 20-plus years that you've been doing this where you believe there were cases that were allegations, false allegations, of molestation that were motivated by profit?
In addition to all the cases that I've seen, I've supervised numerous interns and other professionals. I don't recall seeing any adolescents or pre-adolescents who were making allegations for profit. I do and have been involved with lawsuits where children have alleged molestation, and there have been civil suits and they've been awarded damages. So that wasn't the motivation, but they did proceed with the civil case and they were awarded damages.
All right, but in terms of where you believe that the allegation itself was false?
No.
That was motivated by profit?
No.
No further questions.
No further questions, Your Honor.
Thank you. You may step down.
Thank you, Your Honor.
Call William Dickerman to the stand, please.
Come to the front of the courtroom, please. When you get to the witness stand, please remain standing. Face the clerk here, and raise your right hand.
Respectfully, I'd prefer to take an affirmation.
You may.
All right. Do you solemnly affirm that you will well and truly answer the questions propounded to you under the subject of penalty of perjury?
I do.
Thank you. Please be seated. State and spell your name for the record.
William Dickerman. Dickerman. Discussion held off the record at counsel table.
Mr. Dickerman, good afternoon.
Good afternoon.
Sir, what is your current occupation?
I'm an attorney at law.
And you've been an attorney for how long?
Since 1977.
It won't be a long direct examination. I don't think I have much voice left, so we'll keep it brief.
You need to be closer to the mic, Mr. Dickerman. And they're not hearing you either, probably because of your cold.
Is that better now?
Yes, thanks.
Is that better now?
Yes.
Sir, what kind of a practice do you have?
I'm a civil litigator, trial lawyer.
Are you a sole practitioner or do you work in a law firm?
I am a sole practitioner.
What kinds of cases do you handle typically?
Well, generally civil, or strictly civil rather than criminal, which means anything from contract breaches, to torts, negligence cases, unfair competition, copyright infringement. A whole broad array of non-criminal cases.
Do you know Jamie Masada?
I do.
Is he as a client of yours?
Yes.
And you have represented him at different times over the years?
I have.
Do you know Janet Arvizo?
I do.
Is she a client, or was she a client of yours?
She was, and I believe she thinks she still is, so I'm assuming that she is.
Okay. When did you first meet Janet Arvizo?
February 21st, I think, 2003. Off-the-record discussion held at counsel table.
Excuse me. I'm sorry, tell me the date of your first meeting with her.
February 21st, 2003.
2003. And who was it who introduced you to her?
Jamie Masada.
And what was your understanding of the nature of the problem?
Well, I have to be careful about disclosing any attorney-client privilege. And it's my understanding that Miss Arvizo and her family have not waived the privilege, so I've got to be careful about saying what I was told.
Let me ask you differently, then. Did you meet with her on a few occasions?
Yes, I did.
Was Mr. Masada present on those occasions?
Some he was, some he was not. The initial meetings he was.
Approximately how many meetings did you have with Ms. Arvizo where Jamie Masada was present?
I'd say a total of 3 or 4 in either my office or at the Laugh Factory, and, oh, Gosh, there were other times during the representation when we were all together.
Okay. You did have a meeting with her at the Laugh Factory, is that correct?
I believe there were at least 2 at the Laugh Factory.
What are the dates of those, if you know, or if you have them written down?
One of them I know was February 25th, and there was another one that I don't know the date of, but I believe it was not very long after that date.
Did you engage in efforts to do things or perform services on behalf of Miss Arvizo?
Yes.
Did that involve writing letters?
Yes.
To whom did you write letters?
Well, the first letter I wrote was to Mr. Garrigus, who I understood was representing Mr. Jackson at the time. And there was a whole series of letters to him. After Mr. Garrigus, I wrote, or I'm not sure, maybe it was even before Mr. Garrigus, I was writing letters to various media outlets with regard to the Living with Michael Jackson show.
What was the extent of the problem as you expressed it to Mr. Garrigus?
There were a number of problems that I expressed to Garrigus. And I remember I wrote a letter on March 26 that covered 3 or 4 or 5 of those things.
Was that the first letter that you wrote?
I believe so.
All right, go ahead.
The most serious issue, as I recall, was an intimidation, harassment, surveillance issue that I expressed to him. I was asking him or directing him to cut it out, or to have Mr. Jackson's people stop surveilling, harassing, intimidating my clients.
And what else did you ask for? Did you ask specifically for anything to be returned?
Yes, I believe in that letter, and in several others soon thereafter, I asked for the return of passports, visas, birth certificates. There may have been some other papers.
All right. And did you ask, as well, for other possessions that belonged to the Arvizo family?
I don't know if it was in that first letter. In at least one letter, in fact, several letters, I asked for return of clothing that had apparently not been returned to Gavin when they left Neverland, including tap shoes, shirts, socks, perhaps 1 or 2 other things.
Okay. Were you aware as to whether or not their possessions, in other words, the contents of their apartment, had been moved to some location?
I had been told that they had been moved to some location.
Did you make some effort to notify Mr. Garrigus of that fact and to ask that their possessions be returned?
Yes. I believe it was in that same letter and others thereafter that I asked not only, asked that they be returned, but preliminarily, to get a listing of what those items were, where they were, who had control over them. I wanted a whole listing of things so we would know what there was and what to do with it.
All right. May I approach the witness, Your Honor?
Yes.
Mr. Dickerman, I'm going to show you 2 exhibits. Exhibit number 625 and exhibit number 630 both appear to be a collection of materials. Could you take them both? And let's start with 625. Take a moment, if you will, and look through 625, and tell me if you recognize the content of that exhibit.
I do recognize the content.
All right. And what is that collection of letters?
These are letters mostly to Mr. Garrigus, and at least one from him, with regard to those efforts that you just asked about.
All right. Did Mr. Garrigus acknowledge to you that they had Miss Arvizo's passport?
I don't believe he ever acknowledged it.
Did he ever acknowledge that he had any, or they had any of her other possessions, including the content of her apartment?
At some point he did state that they did have the items in storage.
For the period of time that you were engaged in these communications by mail with Mr. Garrigus, a period of what appears to be a couple months, is that correct?
The first one was March 26 and his last letter to me apparently was June 2, so more than a couple months.
Were you successful in getting Miss Arvizo and her family's possessions returned to them?
Not at all.
Did Mr. Garrigus ever tell you where they were?
I don't believe so. I think he simply referred the matter to Mr. Miller, Brad Miller, who then got in touch with me.
All right. And when was that, the date of that?
Well, on June 2, he wrote that, he asked to have my clients, assume responsibility for the lockers. I don't know that I knew at that time which lockers that he was talking about. But then on June 12, or thereabouts, I received from Brad Miller a letter in which he specified for the first time who had moved the items and where they were in storage.
All right. Up until that point, did Mr. Garrigus ever tell you where your client's possessions had been taken?
No.
What was your understanding of the extent of those possessions?
Well, again, without breaching attorney-client privilege.
Just on the basis of your communication with Mr. Garrigus.
Well, he had suggested to me that there might be 2 vaults worth of material, and my understanding was that there was considerably less than that. Of course, I don't know what he meant by a vault, but I was under the impression that there was not very much that we were talking about at all.
Was it all the furnishings of an apartment?
That was my understanding.
Was this different from your request for materials to be sent back that included clothing, dance shoes and passports?
Well, yes. The only things that I asked him to deliver, and repeatedly, many times, was the items that were recently transportable, the passports, the visas, the birth certificates and the clothing.
Did you learn whether or not your client's possessions were actually delivered to your office at some point in time?
Yes. I got a phone message the day I think it was the day that they were brought over. The office manager was irate that certain things had been delivered or attempted to be delivered, furniture, boxes and whatnot, and it was a day that I was out for a religious holiday. So I was very surprised to find that this had happened. And I was told that those materials had been told to be returned, that they were not offloaded. And I was quite upset about that, because I had made no arrangements with Mr. Garrigus or anybody else for those things to be delivered at any time.
Did you have a message on your voicemail or your answer phone that, answer phone is what I mean to say, indicating that you would not be in the office on that particular day?
Absolutely. Yes, I did.
That's the day that these things were delivered?
That's the day that they were delivered.
Were they actually received or accepted by the office manager?
No.
Or the building manager?
They were not.
Did you talk with Mr. Garrigus thereafter about that?
I don't believe I spoke with him about it. But we did have an exchange of letters.
Again, during that entire, I think we're talking about 8 to 10 weeks, was anything ever delivered to you, where you took possession of it, or, to your knowledge, your client did?
Not a single item.
Did you have actual verbal conversation with Mr. Garrigus during that period of time?
I believe there was at least 1, perhaps 2.
Did you, in the course of those conversations, ask him about your client's passports?
Yes.
And is this passports for each member of the family?
I think so. May I refer to?
Yes, please.
Yes, the passports of the entire family.
What did Mr. Garrigus tell you about the passports, if anything?
I don't recall specifically, without looking at the document that embodies a memo, of what I talked to him about, but I don't think he knew what I was talking about. I remember him.
Well, you have a number of letters to him included in this packet that is 625 where you ask him about passports, do you not?
Yes.
Did you ask him to check into it?
Yes.
Did you ask him about visas as well?
I don't remember. But again, there is a memo of a phone conversation I had with him, and it would be in that, and that memo has been produced to everybody involved in the case, as far as I know.
Mr. Dickerman, at any time during the 8 to 10 weeks that you were dealing with Mr. Garrigus and ultimately communication with Mr. Miller, did he ever tell you, yes, we are in possession of these passports, and we will return them to you and your clients immediately?
No.
Did he ever acknowledge being in possession of those passports?
No.
Did he ever acknowledge those passports existed?
No.
Those communications, 625, that you've looked at, are those letters accurate reproductions of the communications between you and Mr. Garrigus in writing, and in return, Mr. Garrigus back to you?
Yes.
Now, turn to the next group of letters, please. That's 630, is that correct?
Yes.
Excuse me. 630 is a collection of what kind of materials, please?
These are letters to and from, well, from me to various attorneys, media outlets, with regard to the Bashir show, Living with Michael Jackson.
And among the people you wrote letters to are whom?
There was Granada Television, Granada Media Group, the British law firm, of Adelshaw and Goddard, David Legrand at Hale, Lane, which is a law firm in Las Vegas.
Adelshaw and Goddard is where? What location?
In London.
In London, okay.
And finally, the Broadcasting Standards Commission in London.
All right. The purpose of these communications was what?
Well, there are various purposes for the different ones.
Okay. What did they concern in general?
They all concerned the Living with Michael Jackson television program.
All right. What was your concern about that?
Well, The concern as to Granada was that Granada and ITV, which was I believe a corporation associated with Granada in England, they cease and desist from using any program, tape, interview or film footage, whether it was used in the Living with Michael Jackson program or not, for any purpose whatsoever unless they could provide valid consents by my clients, who had been shot in that video or in that program.
Alright. Did all of these communications effectively deal with some issue pertaining to the screening of Living with Michael Jackson?
Yes.
Was there any mention made to you by any of the people with whom you communicated over this issue that they, in fact, represented the Arvizo family or any of the Arvizo children in any claims against those who produced the documentary, Living with Michael Jackson?
Yes, the Adelshaw Goddard firm, especially, or particularly Michelle Boot, who I understood was a lawyer with that firm, stated numerous times that that firm had been requested by Ms. Arvizo to represent her in this complaint.
Was your purpose in this communication effectively to tell them that they were not?
Yes, and to keep them from moving forward with anything that they were doing on the complaint supposedly on her behalf.
And, all right. And did you instruct them not to proceed on her behalf in any other representation?
Yes.
Why did you do that?
Because it was my understanding that she had never given any consent for them to do so.
And was there a reason that you didn't want them representing her?
Because they weren't asked to represent her, and she didn't want them representing her.
Okay. Was it your understanding that you would be representing her on that particular issue dealing with the ramifications of the documentary, Living with Michael Jackson?
Yes.
Now, you sent that collection of documents that you're looking at, number 630, is that, in fact, a complete collection, if you can tell, of all the communications that you had with Adelshaw Goddard and with Mr. David Legrosse?
It was Legrand.
Legrand, I'm sorry. As well as BBC?
Well, I know there were a number of communications. I can't be sure this is all of them. I certainly produced all of them, as far as I knew. I believe so.
To the extent that you're looking at a collection of documents, each of the documents that you see in that exhibit, 630, is certainly one of those letters. Is that correct?
Yes.
Either to you or from you?
Yes.
All right. Did you file a lawsuit on behalf of Janet Arvizo or her family?
No.
At some point in time, did you refer this matter to another attorney?
Yes.
All right. Who was that other attorney?
Larry Feldman.
And why did you do that?
Excuse me, I began representing the Arvizos in February. And by the time I met with Mr. Feldman, it was the beginning of May. In that period of time I had learned a lot of things. There were a lot of allegations being made, and I realized that the best thing for my clients to do, and for me personally as their attorney, was to get some expert input as to matters of Michael Jackson. The initial things I didn't think I really needed to do that with, but as things developed, I wanted to get some input. So I met with Mr. Feldman, whom, by the way, I knew, not by the way. It was very important. I knew that he was, by reputation, he was one of the top trial lawyers in California, if not the United States. And actually, previously, not knowing him except by reputation, I had referred a case to him, tried to refer a case to him that I could not handle for various reasons of an old client of mine. And I knew that he was the go-to guy with regard to Michael Jackson matters. Of course, I knew about the 1993 case, so I met with him, with the idea of picking his brain, actually, not to refer any matters to him. And afterwards, he met with them, and we all associated together. The Arvizos hired both him and me.
All right. Have you filed a lawsuit as of this time on behalf of the Arvizos or anybody else?
No.
Is it the case that the extent of your dealings with them so far, in terms of your communicating with others, has been for purposes of getting their property returned or dealing with the consequences of Living with Michael Jackson, the documentary?
Yes.
Do you have an understanding with Mr. Feldman that should there be a lawsuit in the future, that
They're not hearing you.
I'm sorry?
Behind. These people can't hear you.
I'm terribly sorry. Is there an arrangement that, should there be a lawsuit in the future, that there would be compensation for you in any form of a settlement even if you're not participating in that lawsuit? Do you know what I mean?
Well, we have an agreement.
Okay.
It doesn't say anything about participation or not. We were retained together, and I have a fee-sharing arrangement with Mr. Feldman.
Which means what?
Which means I will get, if there is such a lawsuit anytime in the future, that I will be entitled to a sliding scale, depending on whether there's a settlement or a judgment.
Okay. What kind of lawsuit do you anticipate?
I don't anticipate any lawsuit. My understanding is that there isn't one in the offing. Nobody's talking about one. And I suppose if there were to be one, well, that would be speculation.
Okay. I have no further questions.
Good morning. Or good afternoon, I guess.
Good afternoon.
Mr. Dickerman, my name is Tom Mesereau. I speak for Mr. Jackson.
All right.
You just told the jury you have a fee-sharing arrangement with attorney Larry Feldman, right?
Correct.
And fee-sharing arrangements among attorneys are a fairly standard type of thing, are they not?
Under certain circumstances, yes.
And typically in a fee-sharing arrangement, the understanding is the following. Attorney 1 refers the case to Attorney 2. Attorney 2 files a lawsuit. And if there's a settlement or a judgment or any amount of money recovered, then Attorney 2 has to give Attorney 1 a percentage of the recovery the attorney gets, right?
Under circumstances as they often are, yes.
It's typically called a referral fee, right?
There are situations where there are referral fees, and there are situations where the attorney would be involved in the lawsuit and that's how he would be compensated.
In your typical referral fee arrangement, the referring attorney, being the attorney that sends the business to the other attorney, has an arrangement where, if the other attorney collects money, he gives a percentage to the attorney that referred the matter, right?
In any strict referral fee arrangement, yes.
But what you're telling the jury is your arrangement with Larry Feldman is not a strict referral fee arrangement, correct?
Correct.
Your agreement with Larry Feldman is that you both will share in any fees collected, correct?
Yes.
And that would mean if tomorrow, or next month, or this summer, you and Mr. Feldman decide to file a civil suit against Mr. Jackson, you have an understanding that if any money is obtained, you'll get a piece of that money, right?
Yes.
When were you retained by Janet Arvizo?
Do you mean when a fee agreement was signed?
Yes.
Well, there are a couple of different ones, and they were both around March 24, 2003.
Was that the first date you met her?
No. We met February 21st.
And who was at that first meeting on February 21st?
Mr. Masada, Ms. Arvizo, I was, and I think the 3 children were there, maybe in and out. I believe I met them there, but I don't think they were in on the meeting.
Why was Masada in the meeting?
Well, Mr. Masada was the one who had brought the people to me, and my understanding was that there was no way that they were going to talk to me without him there.
Okay.
He was greasing the rails, as it were, to get them to trust me enough to talk to me. They had no reason to talk to me otherwise.
Okay. And you had represented Masada for many years, correct?
Yes.
And how many years had you represented Jamie Masada at the point where you first met the Arvizos?
I think I began representing Mr. Masada in 1991. Perhaps 1990. So that would be about 12 years.
Had you represented Mr. Masada in any lawsuits?
Yes.
How many?
I couldn't tell you precisely.
How about generally?
Fewer than 10. Between 5 and 10, probably. I shouldn't say that. I represented him in many matters. How many have been lawsuits? I can think of 3 off the top of my head. So there were probably 5.
Approximately 5 civil lawsuits?
I would say so.
Okay. And are you a civil litigator?
Yes.
Do you litigate civil suits from start to finish?
Yes.
And would that mean that you will litigate the case either to a settlement or a trial?
Which case? Do you mean generally speaking?
Yes.
Yes.
Now, you've indicated you represented Mr. Masada in matters other than the civil lawsuits you've just described, right?
Yes.
Generally, what did those matters entail?
Business matters, generally speaking.
Would you consider yourself to be Mr. Masada's principal business lawyer?
Well, he has told me I am. From time to time he's had me coordinate everything, so, yes.
And would that mean you draft documents for Mr. Masada?
I have done that. I'm not a transactional attorney, so if there's something major to draft that does not involve litigation, probably not.
Do you often attend business meetings involving Mr. Masada?
No.
Do you draft articles in the corporation for Mr. Masada?
No. When I say, business attorney, I'm assuming that you mean handling business litigation for him.
Oh, okay. Do you typically write business letters for Mr. Masada?
I don't know what you mean by typically. I have done so.
Okay. Are they typically litigation-type letters or something else?
Both.
Okay. So you do both civil litigation for him and you give general business advice, right?
A little of the latter.
Alright. And at the time you first met the Arvizos, you had represented Mr. Masada for approximately 12 years, correct?
On and off, yes.
Are you the lawyer for the Laugh Factory?
I don't know what that means.
Do you do legal work for the Laugh Factory?
I have.
Okay. What kind of business claims have you handled for Masada?
Well, I think that's attorney-client privilege, and since he hasn't waived the privilege, I really can't go into specifics.
Let's refer to filed documents, pleadings with the civil court. What kinds of lawsuits have you represented him in?
I'll object as exceeding the scope of the direct examination.
Sustained.
Did the Arvizos retain your services or did Mr. Masada?
The Arvizos.
Okay. And would it be correct to say that at the time you were representing the Arvizos, you were also representing Masada in other matters?
Yes.
Now, the documents the prosecutor has given you in the form of exhibits in no shape or form come close to the number of letters you sent or received on behalf of the Arvizos, correct?
Not correct.
Well, are they all of them?
No.
On March 27, you sent a letter to the Executive Vice President and General Counsel of Walt Disney and Company, correct?
I don't recall.
Would it refresh your recollection if I just show you a copy of the letter?
It might.
May I approach, Your Honor?
Yes.
Yes, that's a copy of a letter I wrote.
Does that appear to be the first letter you ever sent on behalf of the Arvizos, do you think?
If that's dated March 27th, I think the 26th to Garrigus is the first one. Actually, I'm not, excuse me. There were a number of letters written with regard to the Living with Michael Jackson show.
Okay.
That may have been well before that. I don't know. If you show them to me, obviously I did.
But they retain you on the 24th, and you sent a letter to Mark Garrigus on the 26th, right?
Well, when you say retain, they signed an agreement on the 24th. As I said, they may have signed. They did sign one earlier that covered different matters. And that's just the formal retaining. That doesn't mean I wasn't their attorney. I was their attorney, as far as I understood, whenever they were talking to me about these matters, whether they signed an agreement or not.
Now, without going into any attorney-client privileged information, which is obviously confidential, when you wrote a letter to Garrigus on the 26th, which is 2 days after you were retained, the basis for your information in the letter had to have been your client, correct?
Yes.
And you suggested in the letter that Mr. Jackson had relentlessly hounded and harassed the children, right?
Yes.
You never witnessed that yourself, correct?
Correct.
You said that Mr. Jackson had hounded, harassed the mother almost daily since they left Neverland, correct?
Yes.
You never witnessed that. You just wrote a letter based on the information given to you, right?
Yes.
You suggested that Mr. J. Jackson had been harassed, correct?
Can you point me to where I said that?
Sure. Right in the middle of that paragraph, number 1.
Yes.
Was J. Jackson your client at the time?
No.
You suggested in the letter to Mr. Garrigus on March 26 that there had been banging on the Arvizos' door at all hours, correct?
Yes.
And certainly you never personally witnessed that, right?
Right.
That came from your discussions with your clients, right?
Right.
You said disturbing notes had been left, correct?
Are you in the same paragraph?
Yes. A little further down.
Yes.
And that information came from your clients, correct?
Yes.
You said on March 26, your clients believed that Mr. Jackson was illegally eavesdropping on their phone conversations, right?
Yes.
And it was your understanding they weren't living at Neverland at the time, right?
Right.
That information, of course, came from your clients, right?
Right.
At no time in that letter to Mark Garrigus of March 26 did you ever mention anything about child molestation, right?
Right.
Now, you talked about wanting passports and visas returned, correct?
Yes.
And at some point you learned that Mr. Garrigus had turned the passports into this court, correct?
I think so, But that might have been a few weeks ago. Or even last week. I don't even know how I learned about it, but.
But you heard about it at some point, right?
I think so. It rings a bell.
That Mr. Garrigus had arranged to deposit those passports in this courthouse?
I don't know that this witness has personal knowledge. Lack of foundation objection.
Sustained.
Nowhere in this letter of March 26 that you wrote to Mr. Garrigus on behalf of the Arvizos is there any mention of alcohol, correct?
Correct.
And you ask for a return in the last paragraph of the papers they have signed, including passport and visa applications, correct?
Not in the last paragraph of the letter.
Paragraph number 2 on the first page, which is the very bottom.
Oh.
I'm sorry. I should have said the first page.
Yes.
Was it your understanding they had signed passport and visa applications?
I did not know about anything that they had signed other. I didn't know about whether they had signed passports or visa applications.
Well, you asked for signed documents in connection with a legal action in Britain concerning living with Michael Jackson, right?
Yes, but that wasn't passports or visas.
Was it your understanding that the Arvizos had signed documents involving the show, Living with Michael Jackson?
There was one document that purportedly had been signed, that I was aware of, by Miss Arvizo with regard to that action in Britain.
Now, in this letter of March 26 to Mr. Garrigus, there is no mention of the Arvizo family ever being falsely imprisoned, correct?
I believe that's correct.
And in this letter of March 26 to attorney Mark Garrigus, there's no mention of the Arvizo family ever being kidnapped, correct?
Correct.
In this letter of March 26, 2003, to Mr. Garrigus that you wrote, there's no mention of any extortion, right?
I believe that's correct. I haven't read this word for word, but it sounds right.
Okay. When you sent this letter to Mr. Garrigus on March 26, 2003, 2 days after you had been retained by the Arvizos, did you ever call the police to complain about false imprisonment, kidnapping, molestation, or alcohol?
No.
Now, you asked for the return of personal property to the Arvizos in this March 26, 2003, letter to Garrigus, right?
Yes.
And your understanding was that this personal property was stored somewhere, correct?
Yes.
How did you know it was stored somewhere?
I don't recall specifically how I learned. Well, without violating the attorney-client privilege, I really can't go into it more.
Okay. But clearly the letter says you want the keys to all locations and facilities in which this property has been stored, right?
Where are you?
Page 2, the very beginning.
Yes.
Okay. Now, in this letter you wrote on March 26, you said that your clients wanted copies of all tapes, films, audio recordings, photographs, images on film, etc., of your clients, the Arvizos, correct?
Yes.
And the reason for that was, you, as their lawyer, thought that any tapes or recordings of the Arvizos may have monetary value, correct?
Well, that gets into the work product doctrine, my opinions and thoughts, and I'm not waiving that.
Okay.
So I can't tell you what I was thinking or why I was thinking it.
But you wanted the tape or film of the Arvizos that was made in the home in the San Fernando Valley within the last 2 months, right?
Yes.
Okay. Have you ever seen that?
No.
Alright. You also wanted Mr. Garrigus, in your letter of March 26, 2003, to provide you with any releases that may have been signed by any Arvizo concerning the show, Living with Michael Jackson, right?
Yes.
And please tell the jury what you meant by release in that letter of March 26.
Well, typically before a production is mounted, whether it's television or movies or anything that depicts an individual, I shouldn't say, generally. Very often, if people are smart, they get a release from the person who's the subject of the show, and that then protects the producers and everybody else involved with the show from liability from the individual who is depicted.
Was it your understanding releases had been signed?
It's my understanding that some releases, some purported releases, had been signed for some purpose.
Okay.
Some.
And you wanted those back, right?
Yes.
Okay. You made a statement that the Arvizos were hereby revoking any release they had signed in favor of Mr. Jackson, right?
Yes.
And you were making a claim that any such release was obtained by fraud or undue influence, correct?
Well, more fully, undue influence, fraud, misrepresentation, false pretenses and/or duress.
Okay, but you mention specifically the word fraud, don't you?
Yes.
Now, as a civil litigator, you're aware of how long one has to file a fraud claim against someone else in a civil suit, correct?
Yes.
And what I'm referring to is what is called a statute of limitations, correct?
Correct.
What is the statute of limitations for filing a claim for fraud in civil court?
3 years from the fraud or from the time that the plaintiff should have known about it.
And based on the date of your letter, Janet Arvizo would have till approximately some date in 2006 to file a fraud claim against Mr. Jackson if she chose to, correct?
I don't know. I don't know when the actionable events would have occurred or what exactly the fraud action would have involved.
Well, you refer to fraud, correct?
Correct.
You refer to fraud in a specific context, correct?
Right.
The context in which you refer to fraud is a suggestion that any releases signed were fraudulently induced, true?
Right. So it would be 3 years from the fraudulent inducement or the time when the plaintiff should have discovered it.
Okay, and you threatened Mr. Garrigus with a civil restraining order, true, in the last paragraph?
Well, I wouldn't say threaten. I say that this is what we intended to do.
Did you ever do that?
It wasn't against Mr. Garrigus.
It involved Mr. Jackson, true?
Yes.
You were threatening to seek a civil restraining order against Mr. Jackson, correct?
I'll take issue again with your description of threat.
Well.
But we don't need to quibble about that. I suppose that's essentially true.
When you used the following words, his failure to heed this demand will force my clients to seek a civil restraining order and perhaps to vindicate their rights in other legal ways, that was a form of a legal threat, wasn't it?
All right.
You said if the items weren't returned by April 1, 2003, you would seek a civil restraining order, right?
No, there is not a restraining order with regard to return of items. The restraining order would only be related to the improper conduct, the harassment, the intimidation.
Okay, did you ever seek that civil restraining order?
No.
You have told the jury that along with communicating with Mr. Garrigus about your client's allegations of misconduct by Mr. Jackson, you were also writing to other parties about the Bashir documentary, true?
Right.
And who were those parties?
Generally speaking, they were the parties that were producing, broadcasting and other ways exploiting the show, Living with Michael Jackson. So there was ABC, and I think Disney is ABC's parent, and the National Enquirer's parent company, I think it's American Media. There was, as I noted before, the communications with Mr. Legrand, who was Mr. Jackson's attorney supposedly with regard to the British action. I know there was some communication with Fox about a subsequent production after Living with Michael Jackson. Various media outlets.
Now, the day after your first letter to Mr. Garrigus on March 26, and I'm referring to March 27 now, okay. You wrote a letter to the Executive Vice President, General Counsel of Walt Disney, true? That's the letter I just showed you.
Well, I don't recall specifically who it was written to, but I did write to Disney.
And you asked them to let you know when your clients had given any legal consent to use the footage of the Arvizos in the film, Living with Michael Jackson, right?
Without having a copy of the document, I can't vouch for what you're saying.
Would it refresh your recollection if I show you the letter again?
Most certainly.
May I approach, Your Honor?
Yes.
Okay.
Have you had a chance to look at the letter?
I briefly saw what you pointed out in the paragraph.
Does it refresh your recollection of what you wrote in the letter on March 27, 2003, to the Walt Disney Company?
Yes.
You asked them to please let you know whether such legal consent, for example, via release, was in fact given to ABC, or Granada, or anyone else involved in the program, right?
Yes.
At that point you didn't know whether they had given releases or not, true?
I didn't know, that's correct.
On March 31, 2003, you did a memo to your file about a phone call from Mark Garrigus, right?
I don't recall the date, but I know there was a typed memo to the file about a conversation with Mr. Garrigus.
And that's when you, excuse me, let me rephrase that. In that call to Mark Garrigus that's referred to in that memo, you talk about him telling you he thinks there either is a vault or two of storage with the contents of the Arvizos property, right?
If you give me a copy of that, or give me a moment to try to dig up my own, I will be able to answer that.
I can show it to you, if it's easier.
It will be a little quicker.
May I approach, Your Honor? Thank you.
Okay.
Have you had a chance to review that memo?
Yes.
Does it refresh your recollection about the phone call with Mr. Garrigus?
Not really. It refreshes my recollection as to the memo that I typed or had typed after the conversation.
Well, according to your memo, you said Mr. Garrigus told you he thought there were passports, true?
Yes.
According to your memo, Janet Arvizo told you the harassing behavior had just stopped, correct?
I really need to see that again, or I have to find my own copy.
I can show you mine, if you want.
Okay.
May I approach, Your Honor?
Yes.
Okay.
Have you taken a look at the memo?
Yes.
Does it refresh your recollection about your discussions with Mr. Garrigus?
It refreshes my recollection of the memo. I don't recall specifically having the contents of the conversation. It was a long time ago.
Was it your understanding that Janet told you that the harassment had just stopped?
If it says that there, then, yes, it did. She did.
Well, it says that there, doesn't it?
Yes.
Okay, alright. You talked to Mr. Garrigus about the passports in a phone conversation, correct?
Yes.
And he told you he thought they existed, right?
Yes.
You also asked him how to get in touch with Bashir, correct?
Yes.
And he said he would try to help you do that, right?
Can you quote that language? I know he mentioned something about Grenada.
I also asked him about Grenada, whether he could find out how to get in touch with Bashir. He said he thought it was Grenada Productions, and I told him I knew of Grenada Television and Grenada LPC. Okay?
Yes.
He said he would try to get me a sheet showing the proper company, right?
Okay.
How would you describe your relationship with Mr. Garrigus at this point?
That was March 27th?
Yes.
Well, at that point he had not turned hostile.
Okay.
So I would say it was just a regular old relationship with opposing counsel.
At what point do you think he turned hostile?
Well, he didn't respond to any of the requests, except in that phone conversation where whatever he said about the passports. He never returned anything. He didn't respond to letters. You go through these letters and I keep on recounting. I've written to you this date, this date, this date, this date, this date. Every time I've asked you, say, please return these things, you don't respond, you don't give them to me, you don't give me the contents of the storage. There's no reason not to return the passports, the visas, the birth certificates. You can get those to me right away. And then especially when he pulls this shenanigan of having the items delivered to my office, not the items, but apparently 2 vaults of furniture in boxes and whatnot that I had specifically never asked to have returned on a date that anybody who had called my office would know I wasn't going to be there, when we had no arrangements whatsoever. And then he has the nerve to write me later on that I had given consent somehow, which of course I never had. That was probably long past the time where I thought he had turned hostile. But obviously he wasn't responding, and it was very surprising to me to have a lawyer of supposedly his caliber being such a hostile and oppositional, adversarial person, when there was really nothing at that point that I knew to be adversarial about.
What you're telling the jury is that a truck came to your office or somebody had been instructed to deliver the things that you requested and nobody would accept them at your office, right?
I wasn't there. All I know is what the manager of the facility told me.
Okay. And what you learned from the manager was that a truck of furniture and goods arrived, and that nobody would accept them, true?
Yes.
Now, in all of these conversations you had with Mark Garrigus on behalf of the Arvizos, at no time did you mention to him anything about child molestation, correct?
Well, I don't think I had more than 1 or 2 conversations.
And you never mentioned anything about child molestation, correct?
That's correct. That wasn't the purpose of the communication.
You never mentioned anything about wine allegedly being given to any of the Arvizo children, correct?
Correct. There was no reason to do that.
The prosecutor, on direct examination of you, talked about your writing letters to England, correct?
Yes.
And you started communicating with a company called Grenada Television, Limited, around April 3, 2003, right?
Yes.
And you wrote to that company to tell them that they were not to use any film footage or likeness of the Arvizos without their consent, right?
Without providing valid consents, as I had described previously in the letter.
And in that letter, you said your clients had advised you they never signed any consent form, right? This is a letter of April 3, 2003, to Granada Television, Limited.
I'm looking at the letter.
Okay, if you don't have it, I can show it to you.
I've got it. That's correct.
You didn't want them taping, filming, interviewing, exhibiting, selling, licensing or exploiting any of the footage involving the Arvizos, correct?
With regard to living with Michael Jackson, that's correct.
Yes. Your position was that any such footage was owned by your clients, and if it had any value, that they owned that value, right?
No, my position was that they had not given their consent to be either taped, filmed, broadcast or exploited in any other way. And we were Sikh.
Excuse me, sorry.
The purpose of all these communications with regard to living with Michael Jackson was to stop the exploitation of the Arvizo family.
You wanted any footage returned to you, right?
I don't see in this letter requesting that anything be returned.
Do you ever recall requesting that any footage or photographs of the Arvizos be returned to you?
I think I wrote something to that effect in the letter to Garrigus on March 26 like we just discussed. I may have later on to somebody else, but certainly didn't in this April 3 letter to Granada.
Did you want Mr. Garrigus to deliver items to your office?
Yes. The passports, the visas, the clothing, the birth certificates.
How about furniture?
No, never asked him, never arranged for it, we never discussed it.
Are you saying that the Arvizos had no problem with the furniture remaining in storage as long as Mr. Jackson was paying for it?
Well, it was unknown to me who was paying for it. It was unknown where these things were stored. And by far, as indicated in these letters, the most important thing to be returned were the passports, visas, birth certificates, Gavin's undergarments, his tap shoes, and the other items that I specified in letter after letter, and we can go through each of those letters if you want to see me specifying them, over and over and over again, asking for only those items. And as to the materials, the items that were stored, asking for a list of items that were stored, information as to where they were stored, who had the key, who had control, so that we could dispose of those items as my clients wished.
And your client, Mrs. Arvizo, told you she had very little furniture that anybody could have taken, correct?
Again, she hasn't waived the attorney-client privilege, so for me to say anything that isn't in these letters would be beyond what I'm ethically and legally allowed to tell you.
Well, if there is a privilege that you were honoring, why did you write on April 8 the following to Mr. Garrigus? She tells me that contrary to what you said about there being a truckload, she had very few possessions, since she lived in a bachelor apartment. She does not believe that much, if any, furniture was removed.
Well, to write a letter to an attorney is not a violation of the attorney-client privilege. Otherwise, one lawyer could never write a letter to another lawyer making any demand on behalf of his client, because then you'd be waiving the attorney-client privilege, which I cannot. It's impossible for me to waive her privilege. And in order to get things done, obviously I've got to describe certain things that I'm told, otherwise there could be no communication.
You wrote a letter to Mr. Garrigus on April 3, 2003, correct?
Yes.
In that letter, you never mention anything about molestation, correct?
That's correct. The only purpose of the letter was to get the items that I had written about before.
In the April 3 letter, 2003, you mention nothing about alcohol, correct?
That's correct.
You mention nothing about false imprisonment, correct?
Correct.
You mention nothing about any alleged kidnapping, correct?
That is correct.
You mentioning nothing about any alleged extortion, correct?
Correct.
And as of April 3, 2003, you have never called the police on behalf of the Arvizos, correct?
Not correct.
You didn't call the police to report false imprisonment, molestation, or extortion.
That's not what you asked. You'd asked if I had ever called the police.
When did you call the police?
I was interested to find out what was happening with the investigation, and I called. I guess it was the sheriff's office, spoke to, I don't know. I know I called. I don't know if I spoke to Sergeant Roble.
Not during this time period, sir.
No, I never called the police to report anything about the Arvizos.
You're talking about calling the police at a much later date to find out about this case, correct?
Right. But your question wasn't limited, and I wanted to make sure that I'm exactly accurate, to the extent that I can.
When did you call Mr. Roble, if you know?
It seems to me it was sometime after June, '03. Maybe October.
October of 2003?
Maybe June, maybe October. I know I've produced for subpoena a sheet of something regarding a phone call to him.
And this would have been after you entered into a legal fee arrangement with attorney Larry Feldman, correct?
Yes.
Approximately when did you enter into the fee arrangement with attorney Larry Feldman?
Probably early May.
So you enter into a fee arrangement with attorney Larry Feldman in May, and possibly a month later, you called the sheriffs to find out about an investigation. Is that correct?
I should probably take back the June. I recall, I think October. But you've got the notes. So if it's June, it's there.
Okay, but right now we're on April 3rd.
Let me clear up something, though, if I might. I don't know what the significance is of a fee arrangement with Larry Feldman. I previously had fee agreements with the Arvizos that were substantially more lucrative to me than they were later on, and what they did was they retained both of us. It was not they retained Feldman, who then agreed to give me a share of whatever recovery there was.
Up to this very date, as you sit here today, you have a fee arrangement with Mr. Feldman, as you testified, correct?
As far as I'm concerned, yes.
Okay. You then wrote a letter to Mr. Garrigus on April 8, 2003, correct?
Yes.
Again, you discussed your client's possessions, right?
Yes. And other things as well.
You talk about allegations of harassment, correct?
Right.
You say that the harassment has not ceased, correct?
Yes.
But in your internal memo to yourself of March 31, 2003, you say that Janet has told you the harassment has ceased, right?
As of that day, she said she was no longer being harassed. I guess it picked up after that, or it was a lull in the harassment.
You just got that information from Janet, true?
Just got what information?
The information about harassment resuming comes from Janet, correct?
Perhaps other of the family as well.
And nowhere in that letter of April 8, 2003, do you mention molestation, correct?
I think I can short-circuit this. I never mentioned molestation, kidnapping, alcohol or any of those.
False imprisonment?
Or false imprisonment to Mr. Garrigus. That was not the purpose of any of these letters. All of these letters were for the purpose of him getting things back to my clients and stopping the harassment.
So in all of these letters, you identify various claims against Mr. Jackson, like harassment, and wanting property returned, and not wanting unauthorized use of the Bashir material. But in none of them do you mention the things I've just described: molestation, alcohol, false imprisonment, extortion, kidnapping, correct?
I've just said that.
Okay. When you mentioned requests for clothes, you're talking about shirts, tap shoes, underwear, socks, etc., right?
Yes.
Obviously, you're told by your client that that stuff's missing, right?
Right.
When you were retained by the Arvizos, was it your understanding that there was litigation going on in Great Britain?
Well, I don't know exactly where, if that is on the timeline. Assuming that February 21st is when I was first retained, because I was, according to my understanding of the law, their attorney when they came to talk to me on that date. I'm sure I did not know. I shouldn't say, I'm not sure. I shouldn't say, I'm sure. I don't know. I don't recall being told about it.
You were considering filing a lawsuit on behalf of the Arvizos against various studios, if necessary, right?
Well, again, that goes into the attorney work product, which is privileged from discovery, and so I guess I should decline to answer that.
Well, you wrote to ABC in New York on behalf of the Arvizos on April 11, 2003, correct?
I don't know.
I can show you the letter, if it's easier.
Sure. Why don't you?
May I approach, Your Honor?
Yes.
Okay.
Have you had a chance to look at that letter?
Yes.
Is that a letter you wrote to a lawyer in ABC in New York named Zucker?
Yes.
That was on April 11, 2003, correct?
I didn't look at the date, but if you say so, that's fine.
You made the statement, "My clients do not wish to make a claim against ABC if one is not founded," right?
Right.
That means they were contemplating making one if it had any justification, correct?
Right. And that claim was to get Gavin's face off television and other media, to stop the exploitation.
You wrote to Mr. Garrigus again on April 11, 2003, right?
Yes.
The subject of that letter is your desire that no footage involving the Arvizos be used by anyone associated with Michael Jackson, right?
Well, it was with regard to a contemplated program by Fox.
How did you learn that Fox was going to broadcast something about Michael Jackson?
I don't recall.
But what you told Mr. Garrigus was that if there was any such program, they were not to use your client's footage without their consent, right?
No. It said that there was no consent and therefore they may not use that footage.
The reason for all of this, Mr. Dickerman, was the Arvizos wanted to be paid if the footage was used, right?
I can't say what was in their head. That was never communicated to me.
Okay.
Ever, under any stretch of the imagination. I'll tell you, if I thought so, I would have been demanding money. I would have said, give me a call, and let's talk about what can be done, or we would have had a phone conversation. If you want money, this is not the way to go about it.
Mr. Dickerman, the way to go about getting money is to tell people not to use the footage and start the process of negotiation right there, correct?
That's not the way that I would do it.
Okay, alright.
Especially with a fellow who was as hostile as Mr. Garrigus was. That's not at all how I would do it.
But you were writing to other lawyers around the country, including Mr. Zucker in New York, and lawyers in England, and lawyers in Los Angeles, in Burbank, right?
I did write to other lawyers. But I can tell you this, there was never a request for money. And the reason there was no request for money is because I was never told, in fact, much to the contrary. I was never told to seek money for any purpose from anyone with regard to Michael Jackson, period.
Did Mr. Masada, your client for many years, ever say words to the effect to you, they're making millions and these poor people are getting none of the money?
I don't recall.
Okay, but obviously he's the one that brought them to you, right?
I don't know what you mean by, obviously, but Mr. Masada brought them to me, yes.
Okay, alright. You got a letter from Mr. Garrigus on April 15th asking you where to deliver the items in storage, right?
Yes.
At that point you certainly knew they were in storage, correct?
I knew that he was saying that they were in storage.
Well, were you representing Jay Jackson at this point?
No.
On April 16th, Mr. Dickerman, you wrote to the head of legal affairs at Granada Media Group in England, correct?
Yes.
You continued to complain about use of the footage involving the Arvizos, correct?
I wouldn't say, complain. I set forth the facts, drew conclusions and made a suggestion to Granada that their position was not right, and demanded that they cease and desist using, living with Michael Jackson, etc.
Now, you also wrote to the Globe newspaper on behalf of the Arvizos, correct?
Sounds familiar.
You complained about their taking photographs of the Arvizos, right?
I don't recall specifically what I said in the letter. But if you show me the letter, I can answer the question.
I don't have that letter, but I have their response to you. Do you have your letter you wrote regarding the Globe newspaper?
Give me a minute or two.
Yes.
What's the date?
I have a letter from them of April 16, 2003. It references a letter you wrote to Michael Kahana, Esquire.
That letter sounds familiar, and I don't seem to be able to put my hands on it.
Were you claiming that the Arvizos had a copyright interest in photographs taken of them that appeared in the media?
I don't know. Depends on what the letter said.
Okay.
I do recall writing to, I thought it was either the Globe or the National Enquirer regarding a photograph of Janet Arvizo that I believe to have been improperly obtained and published.
May I have a moment with counsel?
Let's take a break.
Oh.